Welcome to the Blake Goodman PC Attorneys Podcast. We provide a knowledgeable guide on bankruptcy law in the state of Hawaii so you can stay informed and get the fresh financial start you need. With over 80 years of combined experience in bankruptcy law, at Blake Goodman PC, we're ready to listen and help you get back on your feet. This podcast series is reviewed and approved by founding attorney Blake Goodman.
In this episode, we'll examine the impact of bankruptcy on your digital assets, online business, and privacy. Online accounts, digital assets, and social media are all ingrained in most individuals' daily lives. Whether you have cryptocurrency, a successful social media platform that generates income, or an online store, all of your digital assets could be affected by your bankruptcy. Not only that, but bankruptcy initiates a release of personal information on PACER, public access to court electronic records. With so much of your personal information digitally accessible, you become more susceptible to scams and fraud. However, there is a way to protect some of your assets and prevent so much personal information from going public. If you're considering bankruptcy, consult with a bankruptcy lawyer first to make sure you do what is necessary to protect yourself and your digital assets. Let's begin by examining which digital assets may be seized or liquidated in a bankruptcy proceeding. When you file for bankruptcy, you will be appointed a trustee who will oversee your case. This trustee will look at your physical and digital assets and determine which can be used to pay off your debts. You will not be given a choice as to which assets are liquidated and which are kept, and you are legally required to disclose everything you own to your trustee. Your assets will be treated differently depending on what they are. Here's a breakdown for each type of asset. Cryptocurrency. Online currency such as Bitcoin or Ethereum will be seen as a digital asset and you are required to disclose them. Cryptocurrency changes in its value regularly. The trustee will determine its value based on when you filed for bankruptcy. You will be required to give the trustee access to it, however you store it. Your trustee will determine if it is worth liquidating to repay your creditors. Online business and e-stores. Online stores are considered assets and will be either sold or liquidated depending on the value. This will include your website, customer lists, inventory, and domain name. The business income will be evaluated as well. There are ways to protect your online business. Contact a bankruptcy lawyer to find out how. Social media accounts and digital content. While your personal digital social media accounts are typically not generating revenue and are considered private, there are some situations that could be seen and used as an asset. If you have an account with a significant following or are gaining income from ads or sponsored posts, this could be seen as an asset. Your trustee will determine whether or not this asset should be used. And cloud storage and digital files. Like your social media, cloud storage and digital files are generally considered private and will not be used. However, exceptions to this would be if the file has significant financial value, if you have sensitive business documents on your personal cloud storage, or if there is any other type of valuable data stored on the cloud or digitally. Now, let's go over some essential tips for protecting your digital assets during bankruptcy. Protecting your digital assets is possible, but takes careful planning and benefits from the help of a bankruptcy lawyer. To make sure your digital assets are as protected as possible, you should consider the following. Make sure all your assets are disclosed to the trustee. Transparency is crucial in avoiding legal issues. Keep your personal accounts and business accounts separate. Do so with both your finances as well as cloud storage and digital content. Back up all of your important data to an external hard drive. This ensures you always have access even if the trustee is reviewing your accounts. Look into possible exemptions that could protect some of your digital assets. For example, tools of your trade might be exempt, such as software for your online business. And reach out to a bankruptcy attorney to help you protect as much of your digital data as possible. Bankruptcy attorneys understand all the details and nuances of bankruptcy law and can help you utilize every exemption available. You might be asking how bankruptcy could affect your digital privacy and identity protection. When you file for bankruptcy, your life often becomes public in ways that can significantly affect your privacy. All of your detailed financial and personal information that is connected to your case will become accessible to the public through public access to court electronic records, or PACER. Having your financial and personal information available to access means that you are at a much higher risk for identity theft. You will be flagged by employment screening, and marketing companies will target you. These records on PACER are routinely checked by creditors, employers, landlords, and data aggregators, which could cause difficulties for your future. Next, let's discuss the types of data that will no longer remain private after bankruptcy. What data will no longer be private once you file for bankruptcy? It depends, but in general, you will be required to provide a comprehensive list of personal details that will be visible to the public. The list includes a partially redacted social security number, current and previous addresses, employment history, income details, family member information, tax returns, pay stubs, bank account details, vehicle identification numbers, and property descriptions. Lastly, let's go over some effective ways to protect your privacy when filing for bankruptcy. The personal details that you are required to share and will become public is extensive and could easily be used to create a full identity profile. So how can you protect your privacy when you file for bankruptcy? A bankruptcy attorney can help you, but in general, you can follow a few steps. First, before filing for bankruptcy, you should redact as much unnecessary personal and sensitive information as possible from any documents. Consider using a P.O. box instead of your home address if you can. Second, consult with a lawyer about timing to make sure you minimize any public attention. Third, make sure you have strong passwords set up on your accounts and actively monitor your credit reports for fraud. Remember, you can protect your rights and safeguard your privacy by consulting with our trusted bankruptcy attorneys in Hawaii. Filing for bankruptcy is a big decision that can significantly affect your life. However, bankruptcy can also put you on the path towards financial freedom. Make sure your privacy and digital assets are protected by hiring our Honolulu bankruptcy attorneys at Blake Goodman. We bring compassion and expertise to the table and are dedicated to our clients every step of the way. Reach out to our law firm for a consultation to get started. Call us at 808-556-7833 or visit us online at debtfreehawaii.com.
Thank you for listening to the Blake Goodman PC Attorneys Podcast. Going through bankruptcy can be a difficult and complex situation, but it doesn't have to be if you have us on your side. Your path to financial freedom starts here. Get in touch with the experienced bankruptcy lawyers at Blake Goodman PC Attorney today to explore your options.